Dickson County is now in session. The Honorable Judge David Wolf is presiding. This is the court of the court. God bless you.
Good morning. We'll start with a call of the docket. All right, bring your clients around.
Ask the court if we could turn off the live stream in this case since it's a termination action.
We will, can we stop the live stream and then resume it? Mute it and then turn off the camera.
Thank you.
Oh, we'll have to reset it then. I think so, yeah. Good morning. You have filed a petition, if I understand correctly, representing yourself to request that the child's name be changed, is that correct?
Yes, Your Honor.
And the respondent, or the father's name is Joseph Lonell Bly, is that right?
Correct.
Mr. Bly is, that is, microphone is on, correct? Mr. Bly has contacted the clerk's office and basically said he's objecting to the name change under the current rules that we're operating under by our appellate court's instructions. Anyone who is in custody that it has a pending case must be given an opportunity to be heard on this issue. So we're going to have to necessarily reset your case and set up a Zoom link, either let him testify from the jail or have it heard in person, but the case will not be able to go forward today. You have to serve him with a copy of this petition.
I did.
Okay, and that may be why he's saying today, my understanding was he's saying he did not. Oh, he's saying he didn't get transported. So we're gonna have to reset it. Do you have a date to reset it that you can transport him down here? April the 8th?
It would have to be after that. I do have things on the 8th. That would work.
Right, reset for April the 10th and make sure that there's a notice to the jail that he needs to be transported down for who is the judge? Wallace? Turnbow, Judge Turnbow will hear it on that day.
Okay, thank you.
All right, thank you. Sorry we couldn't go forward. Good morning. If you'll raise your right hand, let's place you under oath.
I do.
You are Amanda Ray Cunningham, is that correct?
Yes, sir.
Ms. Cunningham, you filed a petition asking to change your name, your last name anyway, and I am required by law to ask you some questions. Are you asking to change your name to avoid your just debts or creditors?
No,
Are you asking to change your name to avoid criminal prosecution?
no,
You're basically wanting to restore your maiden name, is that correct?
that's correct.
Then I find there is a good cause for the issuance of the name change. You have an order?
I do.
Okay. I'm going to ask you to sign off on this order. I'm drawing a line here and I'm putting an X there. If you'll put your signature in that, and that extra page is just another copy of the order, blank order, but you can keep that one. I want you to sign that and sign your new name. The reason for I'm doing that is to make sure there's no question that you were here today and requested the name change. So. All right, I've signed your order granting your name change. You can get a copy of it a little later in the morning from the clerk's office, okay?
Thank you.
Thank you. Good morning. If you'll raise your right hand, please.
I do.
You have filed a name request to change the last name of your minor child, is that correct?
Yes, sir.
And have you served a copy on the father of this child?
He is not involved, so when I went to file, they didn't mention nothing about it, so I just,
Do you know where the father is?
in Missouri is all I know.
You do not?
Just in Missouri is all I know.
Well, I understand. It's just that when you may be the custodian of the minor child, is there any court order down that governs, him having any visitation or anything else?
Just child support, that is it.
The child support agency has that, though?
Yes.
I think it's going to be required that you give him notice of your intent to change his child's last name. Because under the law, the rights of a parent to their child don't go away automatically just because they're not involved with the child. You would have to terminate his parental rights. So you may very well have the right to have your son's or your child's name changed, but I'm of the opinion that he's entitled to at least be given notice. And then he may come in and say, I don't oppose, or he may not do anything, and you can proceed by default. But I think you're going to have to serve him with a copy of your request before we can go any further, okay?
Just so, do I need to send that by mail or?
You need to, I can't give you legal advice.
Oh,
The
okay.
clerk's office may be able to tell you, but you're going to have to serve him with a copy of it so that he's aware of your request, okay?
Okay, perfect. Thank you so much.
All right. Ms. Hopwood, is it Lenny?
It's Lena.
Lena? Ms. Lena Hopwood, you are here today to ask that your name be changed. As you heard me say, I'm required to ask you a couple of questions. Are you asking to change your name to avoid your just debts or creditors?
No,
Are you asking to change your name to avoid criminal prosecution?
no,
It's my understanding that you just want to get your driver's license to match up with all your other paperwork, correct?
yes,
All right. Then I will grant your request for a name change, or you have an order. I'm going to do the same for you. I always require that the person seeking to have their name changed sign off on it so that in the future, there's no question that you were the one who requested this to be done. All right. I will change your name to Lanny Alice Hopwood. And I've signed your order. As you heard me say, you can get a copy of it from the clerk's office in a few minutes when they transport it over there, okay? Both of you raise your right hand. Let's place you under oath. All right, this is a petition that's been jointly filed by you to change your name, change your minor child's name, is that correct?
yes,
And you want to change your child's name to Damian Nathaniel, how's it? I can't
Ludlam.
read it.
Ludlam Carpenter.
Luckham
Yeah.
Carpenter? Okay. And his full name presently is Damian Nathaniel Lee Kress. And you're asking to change it to Damian Nathaniel Luckham Carpenter.
Yes,
Okay. And you are the biological mother of Miss Ludlam,
yes,
and you are the biological father, Mr. Kress.
Yes.
And both of you are in agreement that this is in your child's best interest? You're not attempting to change his name to avoid any sort of civil prosecution, any debts or creditors that you may own or that may have some relation to your minor child. You're not asking to change your name to avoid any sort of, his name to avoid any sort of criminal prosecution. And why are you wanting to change his name, just out of curiosity?
He's actually not in his life anymore. He has another man that is his father, and in the future, we're gonna do an adoption.
But Mr. Kress is the biological father, and you're in agreement to change the name. All right. I will change the name. It doesn't change any other parental rights that Mr. Kress as the father may have. No, I'll change the name at your both requests. Okay. You have an order prepared?
Yes.
If- All right, we're going to give you this back and have you both sign off on those 2 lines I've drawn, and both of you as the parties will need to sign off on it, okay? On agreement of both parties, I'll sign the order and grant your request for a name change. Thank you. You can get a copy a little later in the morning from the clerk, okay? Thank you.
This is a petition to register. There was a custody matter that was filed in Yolo County, California, back in 2023. Pursuant to that custody agreement, the mother was granted permission to relocate with the children, ages 13 and 10, back to the state of Tennessee. She has been here, and we filed back in October of last year a petition to register the foreign decree. We attempted to serve the father, and we made concerted efforts to serve him, and he refused to cooperate with the service. I personally, as an officer of the court, spoke to him. He contacted my office after about 4 times of me sending a private process server to serve him, acknowledged that he knew that a process server was going to try to serve him and that he wasn't going to accept it. So at that point in time, I came before the court and asked permission to serve him by publication. And we have served him by publication. We served him as filed with the court. I discovered a newspaper of general circulation in the county where he lived, and that is the Daily Democrat in Woodlawn, California. We filed that, and the dates of publication were February 6th, 13th, 20th, and 27th. No responsive pleading has been filed, so I filed just a motion to set, Your Honor. It's just to register the decree. We're not asking to modify the decree. We're not asking to modify the decree.
Well, I was looking for what I was going to be setting for a final hearing.
Yeah, it's just, I've done an order. It's just adopting, it's just allowing it to be registered so that I can then send that to the California to get a certified copy. I filed a copy with the clerk, but I need to get a certified copy. And it's just a scenario with, we've got a 13 and a 10-year-old that we just need to make sure that this court has jurisdiction over them now, because they do live, if you need testimony, they have lived here. And so that's the reason we're registering it.
Do you need to put on any proof? It's basically, under the statute, you just have to file your judgment and serve him with a copy, and if there's no opposition, then it.
Right, and there's not, but again, we've set forth a specific pleading that's sworn to, so I don't think the necessity is for any additional testimony is
All right.
required.
Thank
Thank you,
you.
Your Honor.
I've signed your order. Diversitas Holdings LLC versus Thomas Shane Sullivan, also known as Thomas Shane Sullivan.
I'm here for the Diversitas, Your Honor.
All right.
This is kind of similar to the last one, where it's just a enrollment of a foreign judgment. The defendant made a sort of bare bones assertion, so we had to file a motion for summary judgment on that, and there's been no response to that. So we're just seeking entry of a summary.
Are you Thomas Sullivan?
Yes, sir.
Mr. Sullivan, let me explain to you the status that we're in right now. a judgment was entered against you in a court in California, and I believe the amount of that judgment was some $88,892.14. That was rendered back in September of 2025. Then the credit holder or the judgment holder, Diversitas Holdings, has brought this to the state of Tennessee, and they filed it under a statute which allows them to domesticate a foreign judgment. That's the process that we're talking about. And what that statute provides is that they can file a copy of the judgment here, serve a copy of it on you, and then unless there's some basis for not allowing it to be domesticated, it would be automatically domesticated. In this case, you filed a pro se or a handwritten objection to it that I don't know if Mr. Townsend, were you aware that he had filed that, I assume?
We were, Your Honor. That's why we filed the motion for summary judgment.
And because of the fact that you filed an answer in November, basically saying that it was taken care of by the finance company and you were told it was over, that I'm treating as an objection to the domestication of the judgment. So what Mr. Townsend has done on behalf of the plaintiff in this case is file what's called a motion for summary judgment. And that motion for summary judgment is under a specific rule of procedure. And that rule of procedure requires them to file an affidavit setting forth all of the facts, as well as a statement of undisputed facts. And a motion for summary judgment is to be granted by this court if there is no dispute about the material facts in the case. The process required you within a certain period of time after you were served with this motion for summary judgment to file a response, including a statement that where you objected to the statement of facts that the plaintiff has supplied. You would have to object to those or agree with those, and then you would have to submit facts of your own. It's a bit of a complicated scenario.
Yeah.
But because you have not done any of those things, then the plaintiff in this case is under the rules of procedure entitled to their judgment to domesticate that foreign judgment under the motion for summary judgment. Does that make sense to you?
No, would you
It may
allow
not,
me?
but have you consulted an attorney at all about this?
That's what I was just gonna ask. I don't understand it because this is almost 10 years ago. I mean, I was in a 3-year lawsuit and Tim Potter was my attorney, and Maximum Finance was the lien holder for the financing company, and they told me that everything was good. They cleared it. I ain't heard a word over this in years, and now.
Well, let me do this. Mr. Townsend, I realize that this is a little bit unusual, but we're required to try to err on the side of caution to try to help pro se litigants. I'm going to reset your motion for summary judgment to allow Mr. Sullivan to consult his prior attorney because he's under the impression that this matter had been resolved by an agreement. You may also contact Mr. Townsend and have them explain it to you, but if you want to contact Mr. Potter, who is your prior lawyer, we're going to give you that opportunity, but it won't be reset for a real long time. So I'm going to reset it for that April 10th day.
Your Honor, I only have a small objection to that, and we'll obviously allow, abide by that. The only objection was that Mr. Sullivan told me the same thing back in November in October when he was served, and then has spent several months doing nothing on this except for a small handwritten response, and has never come back to us explaining his reasons for that. And so that's our only objection, Your Honor.
I understand. And obviously, a layperson does not understand the procedures as well as someone who's trained in the law. And that's the reason I'm erring on the side of caution to give him an opportunity to at least talk with his prior attorney. Mr. Potter is a good lawyer. He's available here in town, so it shouldn't be a long delay. Are you available, Mr. Townsend, on April the 10th? Is that your date?
Let me see, Your Honor. I need to look at our travel schedule. Your Honor, I may have to be in Blount County on the 10th.
What about the 8th? What's your next Chancery?
I could do April 8th, or are you talking about May?
Let's do this, April 22nd. April the 8th is just next week, I think, so.
Right.
April 22nd?
Let me double check. I think that will. No, sorry, Your Honor. I have a motion for summary judgment that day in Morgan County. So
What about the 24th? April 24th. I'm happy to
should-
get these days because
that should work, Your Honor.
I'm sorry, is that day okay?
That day will work, Your Honor.
All right, April 24th. Going to give you that much time to you need to go immediately to see Mr. Potter and explain to him, make sure you've got copies of what all is going on and let him
I hope
take
he
a look
does.
at it.
Like I said, it's been almost, ain't there a statute of limitation on stuff?
I can't give you legal advice. That's why I'm giving you an opportunity to talk to Mr.
I
Potter.
was just wondering why they would wait this many years to,
Well, that, practically speaking, that should have been raised in the California court that was.
well, I was in Tennessee, like I said.
All right. In any event, let Mr. Potter know you need to speak to him, and then we'll reset you on the 24th for Judge Turnbow to decide the case. All right, thank you.
Will that be the same time, Your Honor? Do you want to send those to hearings?
Thank you. 9
I'm
o'clock.
sorry. 9 o'clock. Okay. Thank you, Your Honor.
You're welcome. All right, and then the only other thing we've got is the Hinton versus Hinton, which is Ms. Roberts' case as well. And that's a Humphreys County case that I agreed to bring over to try to conclude today. All right, since Ms. Roberts is working on the resolution of this Dickson County case, before we begin the Humphreys County case, we'll take a recess. Please let me know as soon as. Yes.
May take a while, may take a while to do the NDA on their part.
Are you done with?
Oh, okay. I think we've gotten a settlement in the Jordan matter. Ms. Duke was kind enough to go on and get it typed up. I just need to review it. So I don't know whether or not you wanted to give me a second to review that final decree that we can submit to your honor to settle the Jordan matter, or whether you want us to start the Hinton matter, and then when you take your 10:30 break, just give me a little bit longer at that point in time to review it.
I don't care. I got to hear them all anyway, so matter of fact.
Well, I would
what's
prefer
better for-
rather than the Jordans having to wait.
I would prefer to settle the Dickson County matters completely and get in the docket on the Dickson County so that we can then start the Humphreys County matters.
Yes, if that would be my preference also, if your honor doesn't mind.
Then we'll take a recess to let you do that.
Thank you, your honor.
All right. My understanding is that we are ready to announce your agreement, or does,
What we did on the case, we
Ms.
have a
McKinney,
marital
I
dissolution.
left that file.
On the Jordan case, Your Honor,
Yes.
Ms. Duke Ms. Duke prepared a marital dissolution agreement and a parenting plan. So we have gone, neither one of us brought our notary, so we went downstairs and had the clerk downstairs notarize it. So we don't need, we just need you to sign the final decree. It's not an announcement, it's all signed, and if you would execute that.
Happy to do so. Thank you. All right, I've signed it.
Thank you, Your Honor, and we'll get the clerk to email us copies, and we'll forward that out. And we'll get that out. And so just if we could, just again, for the record, because of some criminal matters that are going on, I'm going to have my client wait in the courtroom until he has to go downstairs. He's got to pay something downstairs. If you're, okay, go on and get your stuff. Okay? You're good. You're good. Okay. Yeah, just wanted to make sure from the officer's standpoint that Ms. Duke would go on and get her client out so that there's not any interaction while we're up here. So, okay.
All right, that concludes then our docket for the Dickson County cases. We have one case that I have agreed to bring over and try to conclude the hearing on, and that is Talisa Hinton versus Stephen Hinton. And we had last been involved in this case in February 19th of 2026 when we adjourned, having not concluded it, and continued it to be heard today. All right.
But this was a case where, oh, yeah, this was one we did not live stream the last time, and probably don't need to do it this time because of some criminal matters that Mr. Hinton's been involved in.